So good day, everyone, and welcome to our webinar today. My name is Robert, and I will be the MC. And in behalf of VF Franchise Consulting, we'd like to warmly welcome everyone, and we're glad that you're attending this webinar with us today. We have a very interesting program that I'm sure you're all going to enjoy. Just a few things to remember before we get started. We will have a question and answer session after the presentation. Due to the large number of participants we have today, you will only be able to type your questions into your device. You will not be able to speak. So you can answer your questions at any time during the presentation by entering it into the chat box on your device. It's usually at the bottom of your phone or the bottom right of your computer. Please conclude your question with a question mark, and it will be automatically registered as a question in the system, and our presenters will address those questions at the end of their presentations. The second thing is that we will follow up with you in the next few days via email with some information and a link to this video recording so that you can review it again. So please keep a lookout in your email for that. So first, before we introduce our two main speakers for this evening, I'd like to introduce our company, VF Franchise Consulting, to you for a few minutes. We are franchise consulting specialists based in Asia. Our headquarters is here in Vietnam, which is where I'm based. We also have a branch in Singapore, and we have partner companies throughout the region. And we do a lot of different things. So we provide franchisor services. We specialize in business development throughout ASEAN and the Asia Pacific region to find really qualified groups for area development or master franchisees on behalf of our clients. We also provide some extra services, especially for franchisors, maybe that don't know the region very well. We can conduct regional studies or country-level market entry or feasibility studies. So we provide a lot of services to assist franchisors who wish to enter this region. We also do some management consulting. So we do a lot of work helping companies turn their brand into a franchise. We help with their business planning, the franchise development strategy, a market rollout plan, operational reviews, and we even create operational manuals and franchise marketing kits. Basically anything that an existing company, which may be you, needs to turn their restaurant or their retail center, whatever it is, into a franchise system. And third, we offer some project-based services. So miscellaneous things, if it involves expanding your business into Asia, especially Southeast Asia, our team is here to help. So again, we can look at systems, we can do mystery shopper programs, we can even help you with recommendations for sites, staffing, short-term training, or other projects. And we always have a large portfolio of clients. Here is our current list. You'll see some very well-known brands on it. Little Caesars Pizza, Texas Chicken, Scholastic World of English, Helen Duran, Ace International. So some very well-known international brands that we are helping currently to come into the Asian region. So that's really what VF Franchise Consulting does. And that's why we've been doing it for a long time. For more than 12 years. And that's why we're here to discuss with you today about what it really takes and why you should be considering looking at our region for your business expansion. So now I would like to introduce our first speaker. So Mr. Alan Adcock, who's a partner and deputy director of intellectual property, will be speaking to us on behalf of Tilleke Gibbins. He is recognized as one of the region's leading IP lawyers and based here in Bangkok, Thailand. Alan will give us some legal and practical overview of franchising in Southeast Asia. So now I'd like to welcome Alan, and we'll turn over the mic to him.
Robert, thank you very much for that introduction and introduction to all the good work that VF Franchise Consulting does. We've been working with you guys for a number of years, and we're quite grateful to be invited to participate in this webinar this evening. I agree with Robert that I'm going to try to manipulate my slides myself, and I think there's just a split-second delay, but it looks like I can control those. Robert just introduced me. I'd also just like to take a quick second to introduce my firm. I've been at Tilleke Gibbins for about 13 years now. Before that, I was an intellectual property lawyer in China for 10 years. This year is a very important year for Tilleke Gibbins. It is our 130th anniversary since our founding in Bangkok back in 1890. We had a lot of events planned for this year, but they've been unfortunately postponed as we get through this recent crisis. In addition to Bangkok, we also have offices in most cities around Southeast Asia. Being the oldest and largest law firm in Thailand, we also are quite proud of the fact of being the first and the largest foreign law firm in Vietnam. And we also have offices elsewhere in Asia, in Southeast Asia. When preparing for this presentation, I spoke with several members of our firm's franchise team across our Southeast Asia offices, and together we thought that we'd like to focus our discussion around these three ideas that you're seeing on your screen now. Recognizing that often there are different ideas between a Western franchisor and an Asian franchisee in terms of what they want to achieve through that franchise relationship. We also thought it'd be important if we could give you a very brief overview of franchise rules in our jurisdictions of Thailand, Vietnam, Cambodia, Indonesia, Laos, Myanmar, and Malaysia. And lastly, this evening, what we're going to do is, after that brief legal overview, I'm going to go over some practical advice and recommendations based on our experience with both successful and sometimes unsuccessful franchise clients. But we want to encourage everyone that Southeast Asia is a fantastic jurisdiction to expand your businesses in. So some of the tips that I'll be giving at the end of the presentation are based on experience with a very limited number of failed franchises. Okay, let's get the stage set by a quick introduction to some important language and jargon that we like to use. As a start, while our clients are always pretty clear on what franchise means, local franchisees, particularly if they've never been involved in franchise businesses, they need to be clear on what's expected of them from the franchisor. So understanding what everybody means on both sides of the aisle in terms of franchise is very important. Common goals of the parties. Here I've given you some examples of common goals that both franchisor and franchisee usually understand are good for both sides. And the first one you see here at the top of the list, mutual benefits, is one common goal that I think deserves a little bit more of attention. So we're going to focus on that quickly. Okay, mutual benefits. What the franchisor wants and what the franchisee wants. Franchisors, they look to franchise opportunities to expand their business outside of their home territories. It makes for a stable income. It's predictable. You can control your sourcing. That drives value in terms of your purchasing. It also drives innovation when their franchisees improve on the business model and report that back to the franchisor, which can then be shared around the franchise network if the franchisor chooses to do so. Franchisees are attracted to these business opportunities because they're proven, they work really well, they're successful. franchisees see all this as sort of a less risky type of business opportunity, and therefore that it makes it a lot more attractive to them. The brands, the trademarks, the signage on the front of the stores and the shops, these are all usually already well known. So franchisees see this as less marketing and promotion that they may have to do and have to spend money on. Of course, that's more attractive to them. But of course, with any sort of commercial relationship, there are differing perspectives between what the franchisor wants and what the franchisee wants. And I've provided some examples for you here. A franchisor may want non-exclusivity to keep his options open for additional franchise partners in the territory. But on the other hand, the franchisee would probably want exclusivity. They don't want to have to compete with another franchisee in the same territory. Something I'll discuss later on is IP enforcement. When third parties may start to copy or infringe or compete unfairly, franchisors may think taking action against these guys should be handled, and most importantly, should be handled and paid for by the franchisee and not by themselves. On the other hand, that franchisee might think, well, you know, you own this intellectual property, so therefore you should pay to enforce it. It belongs to you. It's registered in your name, not mine. Why do I need to pay to protect it from third-party infringement? And also, both sides may likely have different ideas, you know, in terms of how much is paid for the franchise fee, the royalties, and the A&P spend, the advertising and promotion spend. And just quickly, I want to make sure we touch on the intellectual property and what this means. As Robert introduced me as an IP lawyer, I personally, and everyone in the Tilleke team, we always try to encourage clients to identify as much intellectual property as they can in their business model, and to identify this in their franchise agreements, particularly here in Asia Pacific. And identifying and grabbing and putting and referring to all that intellectual property in those franchise agreements, this helps us deal when, you know, occasionally, not that often, but occasionally, when we see instances where a franchisee begins to breach or it might be terminated, the more IP you can find and mention in your franchise agreement, the more grounds you may have and the more meat you can put into a termination notice or a demand letter or something like that on one of those rare occurrences of non-performance or breach of that contract. But we'll talk a little bit more about intellectual property later on in the presentation. Now we're going to start getting more into some of the details of each particular jurisdiction. Let's start with Thailand. Okay, now as Robert introduced, I sit in our firm's Bangkok office, so a great deal of the franchise agreement work that I do is particular here to Thailand. And a lot of times clients are very attracted to Thailand as a franchise expansion jurisdiction because of the fact that we don't have any specific standalone franchise laws here. They may think, well, you know, if you don't have any specific rules and regulations and law on franchise, then maybe that makes me think that it's sort of a cowboy jurisdiction. I can ask the franchisee to do anything that I want. But unfortunately, in those countries where there is no standalone franchise legislation, sometimes it actually means that your local lawyers have a lot more ancillary or related legislation and rules that they have to go through. And I've given you all a brief sort of indication of how sometimes it can be complicated in Thailand because we don't currently have standalone franchise rules. There's a draft law coming up, and I'll speak about that in just a second. This draft Franchising Business Act, it's been in draft form, and it's been around as long as I've been in Thailand, which is about 13 years. It is constantly being reviewed by our Ministry of Commerce, which is responsible for drafting it. There's nothing particularly onerous about it. It simply states what a franchise is, has to be in writing. Franchisor has to disclose enough information to franchisees so they can understand what they're going to be doing. But what's important for a foreign franchise client is to understand that currently the Thailand's Draft Franchising Business Act, it does not seem to be extraterritorial in nature. In other words, it's really only meant to govern franchise relationships that are taking place here in the Kingdom of Thailand. So for foreign franchisors under the current draft, which we've been waiting on for many, many years, it's not going to be applicable to foreign franchisors. But if that foreign franchisor grants his franchisee the right to grant sub-franchises, then of course it would be important to take note of that. Now, I told you at the beginning of my introduction, I was a lawyer in China for many, many years. And I remember back in 2005, the Chinese Ministry of Commerce, they promulgated their first rules on commercial franchising. And back then it had this, what I call a very pesky 2+2 rule. And what that is, I'm sure many of the audience members this evening might understand what it is. It was a requirement that in order to submit a successful franchise application for registration, you'd have to prove 2 franchise business outlets that have been profitable for at least 2 years before you filed the registration application. Now, that came out in China in 2005, primarily owing to a lot of backlash that the foreign business community, I remember the U.S. Embassy, I remember the UK Embassy, I remember all the foreign chambers of commerce. They gave a lot of comments to the 2005 franchising measures, and a couple years later that was relaxed law. There's no more 2+2 rule under Chinese franchise law. Unfortunately, here in Thailand, our Ministry of Commerce has just sort of copied that, what I call a pesky 2+2 rule, and it currently exists in our Draft Franchising Business Act. But just similar to China, the foreign embassies, the foreign chambers of commerce are all lobbying the Ministry of Commerce in Thailand that this is a very unworkable term. Slide 14. At the end of last year, we had promulgated by our Competition Commission the first real sort of guidance on how franchise businesses should operate here in Thailand. That was issued on December the 6th. It became effective on February the 4th. What was helpful about that is that now finally we understand what Thailand is going to consider a franchise, and you see what those 5 factors are, all familiar with everyone here on the conference tonight. Pre-contractual disclosure requirements, sort of something akin to like a franchise disclosure document. All that's going to be important as legislation governing franchise relations in Thailand begins to take more greater form. But now we've been getting a lot of questions here at Tilleke Gibbins from our foreign franchise clients who are asking whether these February 2020 guidelines are applicable to their current Thai franchisees. Now, because these guidelines on what is unfair practices in franchise relationships, because these were promulgated by our Competition Commission, which in and of itself is a very new regulatory body here in Thailand, the Competition Commission has confirmed to us that these guidelines are not retroactive. But we are advising clients that these be taken into consideration when they begin to negotiate renewals of existing agreements. And I think it's probably very likely already that properly drafted Western-style master franchise agreements, which are already being used here in Thailand, like for some of the examples, those foreign franchises that Robert introduced at the beginning of his presentation, those Western-style master franchise agreements that are already being used here, they're pretty likely to already be compliant with these Thai Competition Commission guidelines on what constitutes an unfair trade practice. But it is good to check that. if your businesses are getting close to renewals here in Thailand. And of course, if you're expanding into Thailand, then these need to be looked at very carefully when you're drafting that franchise agreement, or when your lawyers are localizing it here. Just finally on Thailand, very quickly, I want to talk about withholding tax, and something that is very particular to Thailand. Advertising and promotion fees, they're very common in a franchise agreement. These are the marketing and promotional expenses that the franchisor expects the franchisee to pay to continue to drive value to the brand, to drive fame to the brand, to promote the brand. These are actually considered subject to 15% withholding tax, even if that A&P spend is not paid directly to the foreign franchisor. This comes by way of a very unfortunate Thai Supreme Court decision of 2009, which I'm hoping someone is going to maybe challenge at some point. But as far as I know, not many countries around the world would consider franchisee A&P spend to be a taxable expense. Also quickly, another important point for franchise expansion in Thailand, on those occasions when you guys are bringing your trainers out to Thailand to train up the franchisee, on either at the beginning of the relationship or as the relationship grows and matures, and there's new business lines or new product lines, new service lines that have to be trained up to the Thai franchisee. It's always very important to make sure that those foreign trainers do apply for and are given temporary work permits. That's a very strict compliance that our immigration department takes a lot of time to look into. Okay, let me quickly go to Vietnam right now. In Vietnam, there is specific franchise regulation. And again, we've given you some of the names of those laws and decrees and notifications and circulars. And what you're seeing on the screen right now is just some of it. There are more. But important requirements and tips for franchise relationships in Vietnam is that you have to. There is a bit of a proof of concept idea, but foreign franchisors are not required to prove their concept in Vietnam. There are specific regulatory authorities in Vietnam, and the different authority that you would have to go and register your franchise agreement with depends on whether or not you're an overseas franchisor franchising into Vietnam, or you're an existing domestic franchisor. There's a a franchise disclosure document requirement. It needs to be submitted to the regulator about 15 business days before the franchise agreement is actually signed. Trademark license agreements are required. We're going to talk a little bit more about trademark license agreements and the importance of those, being recorded in just a few more minutes. One thing that our Vietnam colleagues always make sure that they inform the franchisor clients of is it's always good to check your Vietnam franchisee partner to make sure that their authorized business scope has been granted for them to actually participate in the line of franchise business that they're holding themselves out as being able to do. So if you are looking to a potential Vietnam franchisee to operate restaurants and food services, then a quick check of their authorized scope of business is very important to do. Here, I'd like to draw your attention to what's required in the Vietnam Franchise Disclosure Document. It really follows along an abbreviated format as the U.S. Federal Trade Commission FDD requirements. So again, there's nothing too onerous here in terms of your Vietnam FDD. All right, let's move on to Cambodia. Cambodia has no specific standalone franchise rules, but there are three particular pieces of legislation that we always spend a good amount of time referring to and advising on when we're taking a client's master franchise agreement and are localizing it for compliance under Cambodian law. And it's particularly those last two that you see here, the trademark and unfair competition law of 2002, and an earlier this year notification on a now new required recordal of license and franchise agreements. And those two things that I'm going to speak about next. The 2002 Cambodian trademark and unfair competition law, it did give us some good information and good background as to what the regulators there in Cambodia are going to be looking in terms of making sure that the franchise agreements are fair and reasonable and compliant. The new earlier this year notification on the recordal of license and franchise agreements, that recordal process now is done at the Cambodian Department of Intellectual Property Rights, like the trademark office. The notification document, it's a form that you fill out along with a copy of the franchise agreement, which can be in Khmer or in English, which is very, very helpful for a lot of clients. It's something that clients are now taking more and more heed into in order for those franchise agreements to be enforceable between the parties. Lastly, on Cambodia, our team there wanted to make sure that this evening I spoke about a current draft law on commercial contracts, which does have a very specific section which deals with franchise agreements. That draft law, again, like the Thai Draft Franchising Business Act, it's been around for many, many years. The Cambodian Ministry of Commerce, while the draft law on commercial contracts doesn't have any specific requirements on proving proof of concept limitation the way that Thai Draft Franchising Business Act does, it does tell us what a franchise agreement it will be. It does tell us the obligations on the parties. It does tell us what a regulator will consider to be a franchise relationship, so that you can't rename it something else. You can't call it a license agreement when in fact it captures a relationship of franchise between the franchisor and the franchisee. But again, that draft law has been around for several years, and we are always keeping our eye on that and figuring out when that might be promulgated. It is in very good shape, and it does give us a little better indication as to how franchise relationships are going to be governed in Cambodia in the future. Okay, Indonesia. Indonesia has specific franchise legislation. I'm giving you some indication of that. Speaking to our team in Jakarta in preparation for this presentation, we have actually seen a slight decrease in the number of franchisors coming into that jurisdiction in the past couple of years. And we're not sure if the number of Indonesian franchises are decreasing because of economic reasons or because of some very sort of difficult to comply with Indonesian laws, particularly in terms of the next slide, which is a somewhat onerous requirement that franchisor, including the foreign franchisor, having to have 5 years of business experience. The franchise regulator or the franchise regulator is from the Ministry of Trade. They do have a reputation of being somewhat prickly when it comes to requirements to record those franchise agreements. Sometimes they can be a little bit contradictory in the advice or the direction or the guidance they give us in terms of what they think might be an unfair term or something like that. It is important to know that this slide 27 that you're looking at, it is applicable to foreign franchisors, and unlike in other jurisdictions, that local language version is required. But here in Indonesia, having proof of 5 years of business experience, sometimes it can limit a foreign franchisor's or it can make a foreign franchisor's interest in expanding their brand into Indonesia somewhat less attractive. Okay, Laos. Laos is a rather small country, landlocked, still very much a developing state. And again, like many of the other countries that I've given you a brief introduction to tonight, there is no standalone franchise legislation. But again, same story, lots of different pieces of legislation and rules and guidelines on what might be important law to be aware of when you are preparing your franchise agreement for Lao purposes. In Lao, I'd say probably our most important recommendation for clients is really in relation to their very important intellectual property that the foreign franchisor is going to be sharing with the local Lao franchisee. It is very important that either the franchise agreement or a short form trademark license agreement be recorded with the Lao Department of Intellectual Property. Recordal of trademark license agreements or recordal of short forms of your franchise agreement where the trademark usage right is set out in that franchise agreement. The recordal of that agreement from a trademark owner to a trademark licensee, from a franchisor to a franchisee, that's very, very important in all of our jurisdictions in Asia Pacific. It's very important in most countries around the world, because what it does, it serves as proof that there is a relationship between the trademark owner or the franchisor and the trademark licensee or the franchisee. Recordal of that license agreement makes it effective between the two parties to the agreement, but it doesn't make it effective to third parties. Another important reason to always remember to record your license agreements or the trademark usage part of a franchise agreement is that when you do so, this recordal serves as evidence of good use for purposes of overcoming a third-party attempt to cancel a trademark based on non-use. Now, different countries have different rules and regulations in terms of how many years of non-use it takes before a trademark becomes ripe for cancellation because the owner hasn't used it. In order to maintain a trademark, you have to prove to the trademark department, trademark office in most countries that you've actually used it. If you record the trademark usage right out of a franchise agreement or a separate trademark license agreement that sort of alludes to the master franchise agreement, what that does is it makes sure that the trademark office realizes and agrees to your franchisee or your licensee's use of your trademark would be considered good use, and that would be good use evidence that you could use to defend your mark if a third party moves to strike it from the trademark registry because they're alleging that you're not using it. So we'll talk a little bit more about the importance of license agreement recordal shortly, but that's very important and highly recommended for Lao to make sure that those license agreements are recorded. Just some other important issues there for Lao. I think one of the things that I wanted to say is because Lao is it's a very developing jurisdiction. Many times when we see foreign franchisors expanding into Lao, they will do so by way of probably their Thai franchisee or their Vietnamese franchisee. In other words, they many times what we see, particularly in services, quick service food, education, convenience stores. A lot of times those Lao franchise expansions they're sort of orchestrated out of Bangkok or out of Ho Chi Minh City rather than with a direct Lao franchisee themselves. And I think that's just owing to the fact that Laos is still a very much developing jurisdiction. It's a little bit tricky to conduct due diligence on a Lao potential franchisee. So what we're seeing recently is when franchisees expanding in Laos, a lot of times those Lao franchisees are actually Thai businesses. Okay, Myanmar, huge country. Again, no specific standalone franchise legislation, but take a look at all that law that needs to be looked at and considered when you're expanding your franchise business into Myanmar. And our first bullet point there, Contract Act 1872. That's not a typo. Remember, Myanmar is also a developing jurisdiction, and a lot of its current and valid law is based on Old English law. So yes, in fact, we do refer, and we have to be aware of the Contract Act of 1872 when we are reviewing franchise agreements for expansion of that business, of those businesses into Myanmar. I just want to say something about the competition law in 2015 in Myanmar. Our Yangon office colleagues specifically wanted me to mention the fact that possibly the Myanmar government should have been promulgating other legislation other than competition law back in 2015. Particularly should have been focusing on intellectual property law. But the competition law of 2015, it does exist. It is something that we have to take a quick look at when we are turning and localizing franchise agreements for expansion into Myanmar. Many times these type of anti-competition rules, they can be navigated around by wordsmithing and adding some participation and decision making on the part of the franchisee to help serve as evidence that their hands were not tied, that they understood and agreed the terms, and that overall the terms are reasonable, and the terms in that franchise agreement, they're not a restraint on trade. Again, it's a conversation you'll need to have with your local lawyers who will be best able to advise on how to handle competition rules. Intellectual property, extremely big news, something that we've been waiting on in Myanmar for many, many years. Just last year, brand new legislation promulgated and enacted. And promulgated, not yet enforced, a trademark law, an industrial design law, a patent law, a copyright law, all enacted last year, but not yet enforced. Trademark law was expected to be enforced this year under a sort of a soft opening period and then a full gear up maybe later on in the year. But unfortunately, that was delayed due to the pandemic. Many trademarks in Myanmar are because there previously was no trademark law. Trademarks in Myanmar were protected by way of what we call cautionary notices. You fill out a form, you give it to the government, and then you run an advertisement of your trademark in a Burmese language newspaper, English language newspaper. We call that cautionary notice. Cautionary notice and declarations of ownership. That whole system is going to be replaced by the new trademark law. And that's very important to be aware of as a foreign franchisor looking to expand into Myanmar. Once the trademark law does come into force, our advice will be to make sure that you rush to the trademark office as quick as you can to file those trademarks. Or if your company already have, or if your clients already have those existing cautionary notices and declarations of use that were under the old system, that those be converted into new trademark registration certificates in Myanmar. But for the most part, Myanmar is a very attractive jurisdiction for foreign franchisors, and we're certainly seeing a lot of growth in a lot of different franchise industries in that country so far. Okay, lastly, Malaysia. Lots of standalone franchise legislation in Malaysia, and you see some examples of that there. And in Malaysia, there's also a specific regulator of franchise and a specific a regulatory authority from the Ministry of Domestic Trade. And again, sometimes Those Malaysian franchise regulators can be a little bit prickly in their opinions. Sometimes they can offer a little bit of contradictory advice, but always best practice to make sure that you localize your agreements so that they are acceptable for registration in Malaysia. Also, the Franchise Act had a very important amendment just earlier this year. Somewhat burdensome in that there is a two-step registration now required, the general registration for any franchisor and a specific registration pathway for foreign franchisors. Now franchise registrations, they need to be renewed, but that system's not yet in place by the franchise regulator. It is set out in the Franchise Amendment Act of 2020, but the renewal of franchise registration still hasn't been fully explained to anyone yet. But we do have some new very helpful definitions of sub-franchise and sub-franchisee. I think that probably the most important point here in slide 40 is the requirement of a 7-day cooling off period. Cooling off periods are very familiar to Western franchisors, so it's not going to be too burdensome. It's just a safety mechanism that the regulator in Malaysia has had in place so that those potential Malaysian franchisees, after they've received sufficient evidence and information about the viability of the franchisor's business plan, they go ahead and sign a franchise agreement, but they are given a 7-day cooling off period where they can actually walk back the agreement of the franchise and step away from it if necessary. Reasonable, I think, in a lot of situations, but it is something that's new, and the franchise regulator certainly makes sure that that's in the franchise agreement. Okay, just to finish up all the legal and regulatory comparisons now, what we've decided to do is to encapsulate that into this comparison chart. And I understand from Robert and from our next presenter from VF Franchising that these slides are going to be made available to all the participants. So I'm hoping this concluding comparison chart might be useful to all. All right, franchising and legal documents. Just a quick general overview. I'm cognizant of my time, so I'm going to try to get through this very quickly. The Franchisor Questionnaire. Now, here in Asia, we really get a lot of foreign franchisors who, before deciding to expand their business here, they ask local counsel to fill out their questionnaires. Now, in the following slides, I've set out several of the general and typical questions that we are asked by foreign franchisor clients as they are considering expanding their business into Asia Pacific, particularly here into Southeast Asia. I'll go through these very quickly, but I won't answer these. And you can feel free to raise any of these to us during the Q&A session after Sean finishes his presentation, or you can follow up separately afterwards if you'd like to. But I think each of these are super important for you to know about if you're thinking about bringing your business here. And you're seeing those very important questions that you might like to get some good advice on or some good direction on as you make your decision to expand into Asia Pacific. I want to draw your attention to questionnaire number 8. Because of growing compliance requirements by corporates in the United States, in Europe, in the UK, in Canada, we are seeing more and more of question number 8 coming up on our foreign franchisor questionnaires. Do these things happen in Asia Pacific? Yeah, they do. clients will vet those answers. They'll make a risk assessment, but they'll certainly provide for risk alleviation in the franchise agreement when it comes to any of these situations you see there in question 8, asking the local franchisee to confirm, to indemnify, to warrant, to represent. So unfortunately, it is an instance or a peculiarity of doing business here in Asia Pacific, but all that risk can be pretty successfully managed by the way that you draft franchise agreement. And just a few more final typical franchise questions that most franchisors want answers to before they decide to expand into Asia Pacific. Okay, just a few more slides before I finish my presentation. I want to talk to you just for a split second on preliminary agreements. I personally am a big fan of preliminary agreements with potential franchisees. When I was a much younger lawyer in China many years ago, I used to see a lot of hardship on foreign franchisors when they had met some potential franchisee at like a trade show or something like that, and then began what they thought were sincere and honest, deep negotiations. They shared lots of proprietary data, and then the potential franchisee just dropped off. Preliminary agreements are very helpful here. They provide at least some basis that you can send a demand letter or something to try to stop an infringer or an unfair competitor. Something that you can rely on and say to them if the negotiations fall through, but then 6 months later, a year later, you see that they're opening or running an unfairly competing business. And preliminary agreements, I'm a big fan of those. They can be binding, they can be non-binding, they can be binding in part. But I tell you, anytime a potential franchisee doesn't at least want to sign an MOU or a letter of intent or at least an IP acknowledgement agreement, you need to take a little bit of pause and ask yourself, is this the right partner for me? If at this very early onset of the negotiations, that potential franchisee isn't willing to sign even a small agreement, just a letter agreement, do I really think he's going to be good for my business? Okay, the franchise agreement, I'll finish up very quickly here. All very familiar to everyone on the call right now. This is the typical sort of franchise agreement checklist. Each and every one of these important checklist issues are already going to be set out in your master franchise agreement. First question on guarantee. Guarantees are very important, particularly if it's a franchisee that you've never done much work with before. I will finish up very quickly now. These are some of the important mistakes that we see in franchise agreements here in Asia Pacific. Of those 7, I was going to specifically mention numbers 3, 4, 5, 6, and 7. But with a view to the time, I'm going to quickly skip over those and talk only about a key mistake that I see in control. Many times, a master franchise agreement is going to have very clear terms that the franchisor has the right to come in and inspect, come in and audit, that the franchisor expects that the trademark be maintained, that the store be clean, that reputation be upheld. Don't forget that because those control and inspection provisions are in that franchise agreement, you always have the right to actually exercise those. I can't tell you how many times we've dealt with foreign franchisors who might have a little bit of a complaint with their local franchisee, and we ask them, well, we see a really good control provision in your franchise agreement. When was the last time you exercised it? When was the last time you visited? When was the last time you called them on the phone about some bad inspection reports? Those control provisions are very useful. They're very enforceable. They're in your franchise agreements. Please be aware of them and make sure that you use them and exercise control. Termination, I always tell young franchise lawyer, in my perspective, franchise is what I call the 4 T's. It's all about the 4 T's. Trademarks, tax, termination, and takeover. Takeover provisions are very, very important. A lot of times, foreigners are not allowed to conduct retail or wholesale services in a lot of Asia Pacific countries. In your takeover provisions in your franchise agreement, if the franchisor itself does not have a legal entity in the country, make sure that if it is a country where foreigners are not allowed to conduct retail or wholesale business, make sure that your takeover term has what we call an appointed representative clause. That means the takeover provision says, if on breach, we terminate the franchisee, either the franchisor themselves or our appointed representative can take over the business. You want to make sure that that store stays open. You want to make sure that the customers are seeing a non-disruption in the business. So those appointed representative clauses are very important in any franchise agreement takeover provision. We talked about Recordal as well. I'm going to finish the presentation now. I'm giving you some information on food registration. Always important if your business is in the food industry. If your franchisee is going to be importing your food, make sure that you time it out. And if you're authorizing them to file the food applications with the relevant Food and Drug Administration, make sure that you know the limitations of that and how you can control it. And with an interest to time, I am going to conclude by saying that no 2 jurisdictions are the same. And while legal and regulatory and cultural differences exist, we've seen nothing but really good success for foreign franchise businesses expanding here into Southeast Asia. Always seek professional advice. Franchise consultancies like VF Franchise Consulting or your local law firm. Local law firms are always the best place to go for good guidance and for good advice. And with that, I will finish my presentation. Thank you for participating.